Good morning, everybody, and welcome back to Law and Crime. I'm Jesse Weber, and thanks for joining us here on the network, where we cover the most interesting live trials and legal stories in the news today. We have a bunch of things to get going on. We have a live trial starting right now, so let's get started. Strong opening statement there by the state, basically saying this was an unjustified killing and going through the details of that. Joining me right now to break this down is criminal defense attorney Ashley McMahon. Ashley, great to have you here, and what a day we've seen so far from the state. What did you think about their opening statement?
Thanks. Great to be here. Oh, my goodness. Well, we have opening statements and closing arguments in all trials. And I would say this is an opening argument. I mean, the prosecutor here was so impassioned. He knows that this is going to be a landmark case. He knows that a lot of people are watching, especially the media, like Law and Crime Network, are going to be watching his every move. And something interesting happened during his opening statement. It doesn't happen very often in practice. He drew an objection from the defense, and usually just out of
several
respect.
Objections, actually. Several objections. Yes, we saw.
Exactly, and he handled it amazingly. In my opinion, and other attorneys may have different opinions about this, but the opening statement is supposed to be just kind of your cut and dry, where you're laying the land for the jury and telling them what kind of evidence that they're going to see in this case and what you're going to present. That's not really what the prosecutor did here. He was arguing his case the entire time, which in my opinion, I think is the right move. I think any time that defense counsel lets you get away with not making an objection and allows you to make an argument to the jury, by God, why aren't you doing it? And that's exactly what he was doing here. And he drew an objection, especially in this video where we saw he characterized the defendant as a crazy man. And as soon as the objection was drawn, he immediately just changed course on what he was saying, didn't miss a beat, and just said, "this man." And he recovered beautifully from that. Right. I thought it was really interesting to watch.
As we continue on with this trial, can you give us a quick understanding, what is self-defense in Florida? What is the law? What should we all be thinking about as we continue watching this trial?
Okay, well, self-defense is the defense of anyone against the commission of a felony or the defense of self. So if you're not often allowed to use deadly force, or really ever, if you're just defending property. But if you're defending your own life, you can certainly argue the affirmative defense, and it's called an affirmative defense because you have to raise it before trial and let the prosecution know that that's what you're going to be arguing as a defendant, that you're arguing self-defense in the state of Florida. So the difference here is that self-defense can change in a matter of mere seconds. Mm-hmm. So the main crux of this trial is going to be the fact that the prosecution is arguing the victim in this case was stepping away and was walking away and was no longer a threat. Yeah, that became a big part in the opening statement, the time frame and how we should be thinking about this. All right, Ashley, he's making some interesting points about this 3 to 4 seconds for the defendant to be, what is going to happen to me? He thinks he's surrounded. He's looking at the threat. He was verbally threatened before this ultimately happened, and then he's hit out of nowhere. Also, it should be noted, my understanding, it was one shot that was fired, not multiple ones, but one shot that ultimately resulted in the death of McLaughlin. So when you think about this, are they raising a good point about self-defense here? Absolutely. I think the defense is doing a beautiful job with what they have here. He's repeatedly said the 11 seconds, 3 to 4 seconds. It's important to keep the jury focused on a timeline here, okay? To keep them focused on the fact that all of this happened very, very quickly. Because the entire crux of the defense here is going to be, there was no time for this to change from self-defense into the defendant being the aggressor. Because like we were stating earlier, that intent can change in just a heartbeat. But as long as you kind of keep it contained for the jury and say, no, it's only 11 seconds. Now he's going into 3 to 4 seconds. this really keeps it in a nice, neat little package for the jury and allows them to think how short of a time period that is. Right. I saw another stylistic thing he did, which was...
Ashley, I'm sorry to cut you off. We have to run to a break. I want you to remember that thought. When we come back, we're going to jump right into this because the opening statements so far have been incredible. Stay tuned. We'll be right back right after this.